The head of IDAC is sitting in front of the Madlanga Commission, and she cannot tell them which affidavit she read. Advocate Johnson runs the unit that is supposed to hunt corruption, and on this day, the commission puts two sets of statements in front of her. Same complainant, same date, the 6th of January 2025. Two completely different versions. The prosecutor, who was actually in that room, sends the commission a voice note. We had one vehicle, we all traveled together, and all meals were done together. So when exactly would Perumal have taken the statements on the 6th if we were together? The evidence leader calls it a post-fact fabrication. Then a commissioner puts it to her. It means this section 27 we are looking at was produced at a much later date and then backdated to 21 November 2024. Her answer? I understand. Asked whether that would amount to defeating the ends of justice, lying to the court, lying to her, she says, correct. That would be correct. And the crime at the bottom of all of this? A 78,000 Rand forklift that was never delivered. Her own words, it appears to be simple breach of contract. Nobody here has been convicted. This is testimony on the record. Like, subscribe, hit that bell. Let's go inside.
I see that.
At the time you signed these summons, what evidence did you have, as by you, of course, I mean collectively the institution IDAC, what evidence did IDAC have to even conclude that there had been manipulation of security vetting processes and unlawful issuing of security clearances in favor of anyone within crime intelligence?
According to me, it would have had to have been the Section 27 referral, and it would have had to have been the supplementary affidavits that had been taken in January of 2025.
And as we established last week, we know that our Section 27 only expresses a suspicion of the commission of this crime without any underlying facts to support such a suspicion. So the answer then must lie in the subsequent supplementaries that we were received.
Correct.
My question then is, what must the commission do if it lands at a position where the supplementary statements do not support a claim such as reflected here? That on reading both this,
I didn't ask for a sorry, Counsel. I didn't ask for a document. I was satisfied with the briefing that I was given. That as an investigation team, they identified that this is the investigation that is outstanding. This is what they require for the investigation, and this is what it is that must be subpoenaed.
It sounds slightly different to what you have just said to the chair. I'd understood you to mean you satisfied yourself that there is not a name in Annexure B that ought not to be there because either there is no evidence supporting it. So I thought you satisfied yourself. But it sounds like I misunderstood you. What you mean is that you satisfied yourself that the investigator who put these names before you had done their work. You took their word for it, and that's how you satisfied yourself.
That is correct.
So you open yourself up because it's your signature that gives authority.
Correct.
You open yourself up for potential manipulation by some of your investigators because you trust them implicitly.
I take note.
I think, Ms. Johnson, unless there's a page missing or pages missing before page 3311, if that's all of it, if what we are looking at now is all of what was presented to you, then the other incomprehensible issue about this letter is that whoever drafted it, whether Mr. Manilal or Ms. Ramsamy, would in fact have put you down at 3311 as the signatory of this letter, because that's what it means. You're a signatory of this letter, and on the face of it, until there's an explanation, which is that the page is missing, then what Ms. Cele is proposing to you, it leads only to that conclusion, which is, well, you either drafted this letter yourself, or a letter was presented, and this is my addition, was presented to you, you made your own changes to it, and then you signed it off. It doesn't contain exactly what would have been presented to you. That's what it looks like on the face of it. And I allow for the fact that a page may be missing, and maybe you can pull out a page that shows that these people made the recommendation, and it provided for you to indicate your approval. But as it stands now, on the face of it, it suggests this is your production.
I can confirm.
Chair, Commissioners, I wasn't moving off topic, but just slightly off topic. And we've had opportunity to consider the documents filed last night and this morning by Advocate Johnson. And on a consideration of those documents, it has become necessary for the Commission to update their exhibit files, because we have what could potentially be documents contradicting the very documents she has filed. And I was moving on to that topic now. A request has been extended that Advocate Johnson have opportunity to confer with her legal team regarding these seemingly contradictory statements before we traverse those issues during testimony. I don't know if Mr. Botlani would like to add anything.
I may just confirm, Commissioners, that it is so. I had a conversation with Ms. Cele last night about what was still outstanding from what had been requested of us. And then I made a request to those instructing me that every document that had been sought must be made available immediately. Even I hadn't had an opportunity to look at those documents. During the adjournment, Ms. Cele confirmed to me that she's going to deal with some of those documents. I conferred with the witness. The witness herself was shocked to learn that there are contradictory documents. We request at least about 15 or 20 minutes of a stand down so that we may consider those documents, confer with her, render advice if and when called upon to do so.
We'll come back when it's indicated to us, then let us adjourn.
That is Mr. Adams's statement. Another time he opened this case in Cape Town, I'm at 3472, in the second paragraph, it reads, a cover-up of Major General Lushaba's Sunnyside case of robbery, whereby official state firearm, laptop, and cell phone was stolen after acquiring the services of a prostitute on 5 August 2022, Lieutenant General Khumalo instructed Major Likalakala and Brigadier, looks like either Monyani or Monyana, it fell off in the copying, to ensure that there would be no investigation into the conduct of General Lushaba as per Valeria case 38/822. The prostitute was paid for her silence using monies from the Secret Service account. New equipment was bought for Major General Lushaba by again abusing the Secret Service account. Evidence to this effect is available. You see where I'm reading?
Yes.
So this particular case relates to the so-called cover-up of General Lushaba's, I don't know if it's a crime, misconduct, but concerns with how Major General Lushaba ended up losing his equipment. At paragraph 2, you will recognize that that statement is our A1 statement in the docket at file 2, page 3478. We have, no, it's not this one. My apologies, I take it back. This is a second issue now. The allegations related, I'm reading at paragraph 2, fourth line. The allegations related to the highly questionable appointment of General Khumalo as the head of crime intelligence nationally. The former Minister of Police, Bheki Cele, was also involved in this, whilst several high-skilled generals within CI were overlooked. At paragraph 3, Khumalo's vetting processes were allegedly fast-tracked by Masemola, who knew that Khumalo did not have a top-secret clearance for many years. And then the last line at paragraph 3, I suspect that the vetting processes were manipulated in favor of Khumalo as well. My interpretation of what's contained in paragraphs 2 and 3 is that former Minister Bheki Cele was involved in the questionable appointment of General Khumalo and overlooking other highly skilled generals. And secondly, at 3, Khumalo's process was allegedly fast-tracked by Masemola, who knew that Khumalo did not have a top clearance certificate. I don't know. I take it fast-tracking in and of itself is not a crime, but what's sought to be expressed here is the unlawful conduct by Minister Cele had the support and participation of General Masemola.
That there could be fraud having been committed because there are certain processes that happen, and there's, it can't happen in 3 days. There's checks, there's, you've got to go and do background checks, financial checks. There's quite a few things that must happen. So it would mean that either something fraudulent happened, which could be the only case, but the bypassing of the vetting would be a contravention then in terms of the intelligence services. So other than the fraud, if it took place, there isn't anything else there that would bring it into the mandate.
The question, Ms. Cele's question is, what places that within the mandate of IDAC? Even if what you're suggesting were to be shown to have happened, they fast-tracked it and they committed some fraud in the process, why would that be something that falls within your mandate in 7(1)A?
Just merely in terms of the fraud, nothing else.
But you do remember that when you appeared last time, you accepted that the fraud, theft, and that list, forgery and uttering, they have to be related.
Yes.
To the main.
To a financial crime.
Yeah.
Or commercial crime.
A serious corruption. So why do you say that would be so in this case? Why would the fast tracking of a security clearance or vetting constitute a serious crime of corruption that falls within 7(1)A?
Thank you, Commissioners. Then on the logic of case number 453/06/25 against General Khumalo regarding General Madondo's vetting or the lack thereof, I take it IDAC is preparing to charge and arrest former Minister Bheki Cele and General Masemola for General Khumalo's own vetting shortcomings. Logic dictates that should follow.
As I indicated, I'm not vested with the cases at the moment, but that logic does follow.
That logic does?
Yes. I can't argue the logic away.
It's on the logic of your answer. Would it be appropriate, though, to be investigating such and threatening to arrest Minister Bheki Cele, former Minister Bheki Cele, and General Masemola for the fact that General Khumalo was hired into crime intelligence without vetting clearance, in the absence of any fact that he in fact did not have clearance, which was an absolute prerequisite for his appointment. Is it appropriate to follow that line of investigation culminating in potential charges and arrest based on what you have at 3475?
No, unless they fall within other offenses that are not here.
Well, it doesn't have an advocate, Ramsamy.
Correct.
And that what we have at CJC 394 are the actual statements taken on the day. And that the statements we have spent the last time working through, commissioned by Mr. Perumal, are a post-fact fabrication. Both witnesses disavow the validity of all these statements, that on the 6th of January, Mr. Perumal did not commission any statement. That's the evidence that we shall hear.
Okay.
And that they were all commissioned by Mr. Rapesu. To that end, because we are armed now with two sets of statements, much like Cape Town-Orlando situation dockets, but that don't speak to each other. The witnesses say they do not know the statements purported to be commissioned by Mr. Perumal.
Okay.
They attest to the documents that the commissioner submitted this morning at CJC 394. It was a bit of a mental exercise to try and marry them, and both have provided short voice notes to explain why it is they challenge the validity of these documents commissioned by Mr. Perumal. And Chair, Commissioners, through you, I beg leave to play. They are very short notes.
Before you do that, does that include 3485? Because 3485 was
it is by Mr. Rapesu.
Commissioned by Rapesu. So
Yes.
should it not be part of CJC 394 if what you are referring to applies to statements in CJC 393?
It would be, except that 3485 was provided by the witness.
Okay. But you're not suggesting that 3485 is also a post facto?
No.
Yeah, okay.
It's only those commissioned by Mr.
Perumal.
Perumal.
The Pretoria, Cape Town.
The Pretoria, the schizophrenic ones, clear, yes.
Then we are clear.
So, so it is necessary that through them, I explain the challenges to Advocate Johnson, and then after lunch, we can then compare the two sets of statements to determine why their advice is important for our purposes.
Understood.
Very short statements. Thank you, Chair. We play the first. The first one will be a female voice, the other will be a male voice. Where you hear a female voice, that's the voice of Advocate Ramsamy. When it's a male voice, that's the voice of Investigator Rapesu. Thank you.
A1 taken by Dylan on the 6th of January, 2026, and then a supplementary taken on the same day by Rapesu, 6th of January 2025. So why would two investigating officers sitting in the same boardroom have taken two different statements on the same day? And I can confirm that in my presence, there was only 4 statements taken. They were the 4 supplementary affidavits, which I have provided to you. The A1 was not taken in my presence, and it could not have been taken on the 6th of January. One, we didn't have the Cape or the Pretoria stamp with us, as is clear from the supplementary statement. 2, Dylan did not take or commission any statements in my presence. 3, we had one vehicle, we all traveled together, and all meals were done together. We even sat at the pool for a long time and chatted and whatever. So when exactly would Perumal have taken the statements on the 6th if we were together?
Thank you. That was the voice of Advocate Ramsamy. And we play the second clip. That should be Investigator Rapesu.
This A1, actually I don't know how to put it, but it could not have been possible because on that day we only obtained the supplementaries. So there was no way Dylan could have obtained that affidavit on that day. And maybe my thinking is that maybe it was signed on a different date, which I don't know. Also remember, I was questioning that signature of Fadiel. It looks like someone was trying to jigger it, but I'm not an expert, I don't know, but it looks like. So I think that affidavit is obtained after.
You say, Chair, let's break. Can I just check something? Ms. Johnson, considering the dates in the Perumal, I'm going to call it the Chief Perumal statements, which is the 6th of January, and then on the same day, Rapesu also, it's the 6th of January. Would it be normal, I can't think of the correct word, but that you would have an A1 statement on the 6th of January taken by a member of this 3-member team, and on the same day you have the same team, you have a supplementary statement. It seems to me intuitively that you just have one A1 statement if they were all traveling together and they were interviewing the complainant together. Am I right that
Correct.
you would have one comprehensive statement?
Procedurally, it does not make sense.
Yes.
What might have made sense is there were 4 statements to be taken. If perhaps Mr. Perumal took 2 and Rapesu took 2,
Yeah.
but on those same matters, and then they end up with a total of 4,
Yeah.
that is logical. But you cannot have one team together, same day, same place.
Taking a main statement and a supplementary statement.
And bearing in mind, Chair, that the purpose was for a supplementary statement to bolster the dockets that were purported to be somewhat lacking.
Thank you.
I think it highlights the danger I mentioned 15 minutes ago,
Absolutely.
where only one person is engaging or not engaging with a witness. But advocacy law, something even more important. In the docket and in the various documents that were given to the court, what was disclosed? Is what was disclosed what we now know as the doctored A1, or is it the correct supplementary?
So far, we have the Mukwele docket that we have worked through. It is what the commissioner calls the doctored A1. That's the A1 in the Mukwele docket.
I mean, that is serious misconduct. It's serious misconduct.
It is indeed.
Because it means that is what is disclosed to the court and to the accused.
Indeed, Chair. Indeed. Okay,
I'm not sure that we can confidently say or accept what you're saying. I mean, we've seen what happened with the Mukwele matter, which you have considered. The facts are very poor for the issuing of a warrant, for an investigation, let alone for a prosecution, an ongoing prosecution. So that should be our point of reference, the Mukwele matter. This seems, from what you're saying, may well be one of those cases where charges were going to be preferred. An investigation certainly is happening. Charges were going to be preferred. It would end up in court when, in fact, on the face of it, it shouldn't have happened. And it happens because of other reasons that have nothing to do with the merits or the strength of the case. It's an observation that I want to make in the light of you saying, well, maybe nothing would have come of it. And yes. I'm saying, well, the Mukwele matter teaches us that, well, something can be made out of nothing by IDAC, as it happened in Mukwele.
I hear you.
Advocate Johnson, my reading of these documents, and I must admit I read them very quickly, so I could be wrong, is that there was a proper requisition and it was approved at all levels. The issue is the failure to deliver by the supplier, and the money must be recovered from that supplier because they failed to deliver, but they have been paid. So what is manipulation there? If I order goods because they are required by crime intelligence, and then the supplier gets paid but does not deliver, how does that rise to manipulation and fraud and corruption?
It does not, Commissioner.
Just on those facts, I mean, we looked at 3504, where the person says, is the colonel, says, there was a requisition, I was the applicant on behalf of fleet management, I requested a forklift for the unit, an application was completed and submitted to procurement, the forklift was required to move and store accident damaged vehicles. After the processes were complete at procurement, a supplier was awarded a tender. The supplier, that's the next paragraph, was paid a deposit for securing delivery of the forklift. The proof of payment is attached. The supplier did not deliver. And further investigation into the matter must be conducted in order to recover the monies paid to that supplier. So if those are the facts, what is the manipulation of procurement processes, and what's the fraud and corruption?
It appears to be simple breach of contract,
It does, Chair.
a civil, not criminal.
The last then statement taken by Investigator Rapesu on my record is a 3493.
3493.
That statement, if we start at paragraph 2, reads thus, and I quote, "On or about early October 2024, I received information anonymously surrounding alleged crimes emanating from the Division Crime Intelligence of the South African Police Service." Paragraph 3, amongst the information, it was alleged that Secret Service funds were used to purchase resources for the political killings task team based in KwaZulu-Natal province. This task team was previously led by the current Divisional Commissioner of Crime Intelligence, Lieutenant Khumalo, who has close ties with the former Minister of Police, Mr. B.H. Cele. Paragraph 4, it is alleged that the resources procured under the banner of the task team were for the benefit of Mr. B.H. Cele and others. We know that our Section 27 is doesn't even reference the PKTT at all. No, that's a reference to Minister Bheki Cele.
Yes.
And that
that's
is
what I'm saying.
regarding his
That's the
appointment
only
of General
reference.
Khumalo.
Yes.
I'm particularly interested in reference to PKTT because he takes 2 paragraphs to deal with PKTT, draws in Mr. Cele and General Khumalo, and even points out that the General Khumalo he is referencing previously led the PKTT. So these are specifically PKTT-related allegations. Now, if one reads Section 27 affidavit as it stands, then short of lunacy for Investigator Rapesu, Advocate Ramsamy, and Chief Perumal collectively to take a statement regarding PKTT, to call it a supplementary affidavit. If not that, then I don't know. Can you help?
Makes no sense.
Absolutely.
Then it talks to how did these other supplementaries come about still with the same date? And when did that 27 come about?
Let me correct you, and to the extent that you may have understood me to suggest that, I'm not suggesting there was an additional Section 27. Their testimony, as they have indicated they will testify, is that the Section 27 affidavit we have been sitting with here and working on is not the Section 27 affidavit. The Section 27 affidavit, and we agreed it has to be one, had references to the forklift patches and had direct reference to the PKTT, both of which are missing in our version. So I'm saying there appears to be two when there should be only one, but it's not suggesting parallel processes. You can only have one process. These are members of IDAC, all of them, following the same Section 27. Now, where that potentially lends me is, are we confronted with a fraudulent Section 27? I'm thinking, and I pose that question, if not, how do we potentially explain these discrepancies?
Am I able to ask who took that 27?
I don't know. I promise you I wasn't there.
No, I'm saying in terms of what the witnesses might have provided, because this one that we have, commissioners, is the one that has come from that was done in Cape Town and I think commissioned by a Ms. Solomons. I'm not sure who would have taken that one. It's important for me to have sight of it if council allows. But I have also only this one.
But who commissioned it surely is not a relevant issue. The concern would be if there are two, regardless of who commissioned either one. That's my concern. The potentiality that we may be actually dealing with two, the second of which has not been disclosed to the Commission.
But
And that would be the chief.
Do you understand the difficulty? If you look at the supplementary affidavit on 3493,
Yes, sir.
it is dated 6 December 2025. These three people were together in Cape Town on that date. And the simple point Advocate Cele is making is that on that date, as they were taking this supplementary affidavit, there was only one Section 27 affidavit, and it is not the one that is in our files. It is the one that made reference to PKTT and forklifts and other things.
Okay, sorry, now I understand.
The one that we have in our files is not the one they were working on the 6th of January 2025. Now, if that is correct, then it means this Section 27 we are looking at was produced at a much later date and then backdated to 21 November 2024.
I understand, Commissioner.
Because if it existed on the 6th of December, then all three of them would have been looking at this one and not the one that they refer to in the clips.
Understood.
And that is a serious problem because it affects you as well. It raises this question. The Section 27 you looked at in November or December 2024, which one was it? Was it this one that we are looking at or another one which has not been provided to us?
And this is the one that comes to mind.
Are you sure that you said to ad hoc that the first time you saw a Section 27 affidavit was sometime in December? You said middle December, then you corrected yourself and said before 6 December. Which affidavit did you look at in early December or mid-December? Was it this one or was there? Are you now no longer sure which one it is?
No, I saw one.
We're now focusing
positive.
on content, because an affidavit is an affidavit.
Correct.
The one that you looked at in December, did it make a reference to PKTT and forklifts and other things?
Chair, I honestly...
Are you no longer sure which affidavit
I
you
cannot
looked at?
remember that I saw that, the forklift and the PKTT.
Say that again?
I cannot recall seeing forklift and PKTT.
But do you remember which affidavit you looked at in December 2024? Are you now no longer certain?
Now that you're putting it to me, I can't give you a definitive answer. I don't know which one I saw. This one is the most familiar, let me put it that way, from having worked with the statement. This has always been the one that has been most familiar, and this is the date I recall.
Because it could be that even the one Mr. Rapesu is referring to also had the same date. So don't focus on the date. Let's talk about the content. What was in that affidavit? Did it make a reference to PKTT and forklifts and other things?
Apologies, Commissioner. I can't recall all that detail.
Thank you.
I do apologize. I can't recall all the detail.
No, if you can only give, an honest answer, if that's the honest answer.
I cannot recall.
Yeah.
Becomes a deponent. Because on these facts and the mess that has happened here, it seems to me it's not inconceivable that Mr. Adams could turn around and say, but I don't know anything about that, which you say Perumal signed, commissioned. If it turns out that Chief Perumal went and did his own thing, wherever and however, surely the official statement of IDAC would be that which was done by the three of them together and deposed to by Rapesu. Is that a fair?
It's a fair assessment.
It's a fair assessment and proposition to make, right?
Correct.
Okay. Now on that, if in fact, as we know it has happened in the Mukwele matter, if the docket that is before the court and that is disclosed to the accused, and that is the basis for the warrants that were obtained for instituting for the charges, it is in fact Perumal's questionable statements, not the ones that were properly taken. That would amount to. It seems to me that would have amounted to defeating the ends of justice, lying to the court, lying to you, misleading everyone that is involved with this, and failure to disclose the true contents of the docket. Am I correct in all of that? I'm assuming Perumals are in fact a manufactured statement that is being used.
Correct.
That would be correct?
Yes.
Okay.
And
that would undermine the prosecution itself, right? The entire prosecution, because it's based on A1 statements that are questionable, as in they've been made up by Chief Perumal, whether with or without Mr. Adams, but they're not an official record of the IDAC.
Correct.
Okay, thank you.
That midway, where it says Advocate Johnson, you suggest there that you will deal with the arrest of General Khumalo, and then you indicate from line 2, and I would just for purposes of completeness indicate that IDAC is not aware of these cases that were made, be they by Mr. Matlala about theft, by Gatiso Molefe, the ballistic case, or any other case that has been made against any of the PKTT members. They are not allegations that IDAC is looking at. That was your testimony. But from the supplementary statement by the three, that can be entirely correct, because that statement we just looked at page 3493, file 9, is specific about PKTT. So,
I see that, yes.
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 So
I wouldn't have seen the wouldn't have seen the supplementary.
I can accept that, but then it suggests that your investigators withheld from you some detail on some of these investigations. From the reading of your transcript at ad hoc, it would appear that you were not even aware that PKTT was being investigated or considered for investigations. I put it no higher than that.
Correct, and that is why when there were the utterances that IDAC was involved in PKTT's business, I was taken aback because, according to me, there's nothing for us to look at in PKTT, regardless of what allegations may have come to the fore.
And if those were the allegations that you are hearing of, now that we have seen the supplementary affidavit at 3493, those claims were not entirely baseless now, were they? That IDAC is, what did you say you had understood, is interfering in PKTT? They don't appear to have been entirely baseless.
Yes, when you look at 3493.
Yes.
Correct.
Okay.